Okay, good morning. This is Alyssa Witt, and I am coming to you live from sunny San Francisco. It's a gorgeous day downtown. I manage our partnership team here at Ubiquity. We are a digital provider of small business and startup 401ks, and I'm very excited to have Jason Roberts on our webinar today. So to give you a little background about Jason, he is the founder and the CEO of PRI, Pension Resource Institute. PRI is an institute that delivers compliance consulting to plan sponsors and financial institutions. He is an ERISA tax and investment expert and has founded the Retirement Law Group, which specializes in such matters. Accolades that Jason has received: he was mentioned 401k Wire's 100 Most Influential People in Defined Contribution. His education includes a BS, BA in Finance and Banking from the University of Missouri and a JD from the UCLA Law School. So he's someone who likes to take a lot of exams, or at least does well in them. We're excited to have his expertise on this subject. And when he's not interpreting Department of Labor regulations, you can find him deep sea fishing. So welcome, Jason, and thank you for being here today.
Thank you, Alyssa, and thanks everybody for dialing in. We're going to jump right in, but I wanted to set the stage somewhat here about what the real goal today is with the presentation. And what we're going to do in the first half of today's presentation is talk about, or maybe the first quarter, talk about supply and demand and what are the plan sponsors' challenges that are having them, that are prompting them to look for retirement plan advisors and consultants to support their plan and its participants. How is the financial institution, the community, prepared to respond from the number of specialists in the marketplace? We'll talk about one of the key reasons why they do need help, and it may surprise you, it typically has very little to do with selecting and monitoring plan investments. We're going to dig into some of the other aspects of plan governance where plan sponsors typically need more support. And then we're going to finish out by talking about how do you then scale the delivery of those additional services that may make you as an advisor a more attractive option given the increasing preferences of plan sponsors for more holistic support. How do you add these additional services and yet preserve the scale that allows you to run a profitable and sustainable practice? And then, as Alyssa mentioned, we will open it up to questions from the audience. So this is always interesting. This information came from a 2016 Willis Towers Watson Plan Governance Survey, so it's very specific in terms of the questions it asks, and they do relate to plan governance related items or activities that the plan sponsors are responsible to perform. It comes out, I believe, every 3 years, so we'll have a new one out soon. But in the latest version of this, we saw half of plan sponsors citing regulatory compliance as one of their top 3 concerns they have with respect to managing their plans. We saw also that a third of those plans had faced some form of a governmental audit over the past 2 years. That's primarily Department of Labor investigations or IRS audits. And that if you get into the large plan market, half of those employers have submitted to a governmental audit in the past 3 years. And the reason that we're going to see here in a minute of the increasing demand from plan sponsors for more expertise from financial professionals is that they're reporting they have barriers, that the legislation or regulation, primarily the latter, the regulation, has evolved at such a rapid clip that plan sponsors are very hard-pressed to stay on top of what is required of them at any given time. The pullback of the Department of Labor fiduciary rule certainly has not helped. It's added to more confusion with plan sponsors. And again, one of the themes here today is how do we reverse engineer that confusion and prepare you proactively to be able to solve these issues, potentially even before they ever come up, but certainly something that you can prepare to assist your clients with, so when they do come up, you are able to efficiently solve whatever that challenge is. And one of the big barriers, not only are the rules evolving so quickly, but then also the plan sponsors, as I'm sure you are well aware, the retirement plan, particularly the 401k plan, isn't always the number one agenda item or the most pressing issue for these employers, whether it's HR or CFO or whoever is on the plan committee or making decisions on behalf of the plan. They're likely also dealing with healthcare and other employment-related issues that other benefit plans even potentially that are taking away from the time they have to spend on the 401k plan. So we'll unpack that as we get further into the deck. But this is just kind of some high-level observations as reported by Willis Towers Watson that I think you're going to find are relevant to what we're going to look at next, and that is plan sponsor survey results. I did just hear yesterday that the 2018 results are in. I don't know that Fidelity has made them available publicly yet, but I anticipate we're going to see more of the same. This has been a trend. It really took a jump last year. The area that jumped here the most is the 38% of plan sponsors that are surveyed report they are actively looking to change their advisor. And so if you are an advisor trying to retain your clients, that may be somewhat alarming. If you're an advisor trying to prospect new opportunities, then I think it bodes very well, and it will dovetail nicely into what we're going to talk about today, which are some strategies for differentiating, starting conversations that maybe other advisors aren't having, and even working with plans that may currently have no advisor, being able to articulate why they should consider engaging you. One of the reasons you can see down here, 55% said that it was a solicitation from another advisor that has piqued their interest. So being able to tell that story not only to your current clients from a retention perspective, but also to prospective clients is certainly generating this anxiety, if you will, among plan sponsors that maybe the incumbent advisor, that person may serve the personal wealth needs of the business owner, or maybe somebody else in the C-suite, and that's how they were afforded the opportunity to work with the plan. But maybe they're not a retirement plan specialist, and so the plan sponsor understands that there may be better value out there that can help them save time and better manage the risk. And so when the Fidelity drilled down to ask why this would be the case, why are you actively looking for a new advisor, 40% of you, the attributes that they're looking for is obviously plan expertise. We'll see one of the alarming statistics here in a minute that relates to how many advisors actually do have a retirement plan expertise that they can deliver to their clients. Ability to understand the employee's needs and the company's needs, and helping with fiduciary requirements. And so that last one, although it's 15% in terms of the most valuable advisor services, 70% or 76% say that they have hired or are considering hiring someone to help with fiduciary duties. And we'll look at that graphically here in a moment, but fiduciary duties span much more than just investment duties. So that's where the focus of today's call is going to be. So with that backdrop, let's look at what the supply side looks like. And when we look at financial professionals, there's something like 350,000 nationwide that are licensed securities professionals. When you start asking about retirement plan expertise, just the number of advisors that serve at least one plan, that number goes down to 150,000. Those serving 3 or more plans goes to 75,000. And by the time you get out to over 5 plans, you're now among 15,000 financial professionals in the country that have that level of expertise. And then what is the most expertise, at least in this survey, and this was the Retirement Advisor University is where these statistics came from, That is 5,000 advisors have currently served more than 10 plans. So not a real high bar to be in that elite 5,000 community. And again, one of the things that we're going to leave you with today, including some of the takeaways that you're entitled to print and use as you see fit, that should help you open the door to, if you're not quite at the 10, if you just have a couple, but you recognize this as an opportunity to grow your revenue and in a very rewarding environment. Also, there is an opportunity to work with the employees outside of the plan. We'll get into some of the nuances about that. But it can be a very profitable and rewarding enterprise. And if you get into that 5,000 or fewer advisors that serve more than 10 plans, that's something you may want to consider including in your marketing materials and your elevator pitch and so forth. So I alluded to this earlier, but this way where we can see graphically how plan sponsors become fiduciaries. Sometimes it's through a very formal structure. They may be named in the plan document. They're a trustee of the plan. They're also the ones that are making decisions relating to these three areas where you can trigger fiduciary status. Sometimes it's informal. Sometimes you may have somebody that agrees to serve on a committee. They're doing things they just think are helpful to the committee's purpose, but then they're exercising their right to vote on a particular issue, or they may even exercise discretion over that issue without even knowing it, and that will trigger fiduciary status. So when you think about the ways that one can become a fiduciary under ERISA, there's only two ways that an advisor typically becomes a fiduciary. One is they either provide investment advice. Now that is sort of a changing target, if you will, because that is what was at the crux of the Department of Labor fiduciary rule, was redefining the phrase investment advice, and therefore expanding the number of advisors that would be considered fiduciaries. The other way an advisor can become a fiduciary is by exercising discretion over the plan investments. That's when you don't accidentally find yourself in a position where you have discretion. That's something you're going to contract for, and you'll know it when you have it. But investment advice, that's somewhat of a fine line, and we'll want to make sure you understand which side of that line you're on. A plan sponsor, however, though, can be a fiduciary in a couple of other ways. Number one is by exercising discretion over plan assets or the management of the plan. That would include things like hiring and firing service providers, including yourself as a financial advisor or consultant or what have you. The third way that a plan sponsor can become a fiduciary is exercising discretion over the administration of a plan. And so we've given that its own category. That would be things like determining eligibility investing, approving loans, etc., filing reports with governmental regulators, making sure that required notices are getting distributed to plan participants or eligible employees, etc. And so, as you can see here, there's somewhat of an imbalance. And the imbalance is that all three of these duties are equal in terms of the fiduciary requirements. However, as you can see, the number of activities, even in our sample list here, the administrative activities far outweigh the investment-related activities. The service provider falls in the middle. When you start thinking about risk and reward in terms of maybe where you want to encourage plan sponsors to spend their time on the highest risk and highest reward activities, I can confidently say that very infrequently do plan sponsors find themselves on the wrong side of an enforcement action or in court defending claims relating to investment performance, particularly if they have an investment advisor that they've retained to help with the process in selecting and monitoring those funds. They're even less likely. So it's relatively low risk. I think the exception is some of those cases we've seen filed lately where they're alleging that the plan sponsor acted imprudently by selecting a money market as the cash equivalent for that plan versus a stable value that would have had a higher return. From what I can tell, all of those claims have been dismissed with the exception of a few that have settled. Ultimately, if they have not been dismissed and they work their way through the courts, those should not be able to lead to liability for the plan sponsor, because it does not require plan sponsors, or risk doesn't require them to pick the best performing investment. It doesn't require them to be perfect. It requires them to be prudent. And as long as there's a reasonable process in place to select and monitor those investments, then ERISA would provide them with protection against a fiduciary breach claim. There are some opportunities for improvement on the investment duties, particularly with respect to qualified default investment alternatives, or QDIAs, and even more particularly when it comes to target date funds as the QDIA, and we'll talk about that in a moment. So in this regard, we believe most financial professionals are well equipped to follow a process and help a plan sponsor select and monitor funds in a way that mitigates the plan sponsor's risk and doesn't create unnecessary risk for the advisor, particularly if they're trained on doing that in the context of an ERISA plan. They're relying on an investment policy statement, and they're using a firm-approved, supervising firm-approved investment analytics software that's going to generate the report. That's relatively low risk, counterintuitively, right? But it's a relatively low risk for the plan sponsor and the advisor. And it's, I would say moderate reward, because we know that the biggest impact on participant savings is going to be their deferrals and not their allocation. So having the ultimate in terms of performance in each asset class would not make as much of a difference as dialing up 1% across the board in terms of deferrals. So we'll chalk that up as moderate reward. But over here on these other two items, on the service provider side, in terms of risk, that's where we do see the most litigation. The litigation speaks to investments, but it doesn't speak to them in terms of performance. Primarily, it's talking about share class and revenue sharing, and that's why we would lump those claims into the service provider category, because it's really, those claims have been about who's getting paid from the plan, whether it's a legitimate plan expense, how much are they getting paid, what value are they delivering to the plan in exchange for that compensation, what potential conflicts do they have, et cetera. So that can be a high-risk item, particularly for larger plan sponsors. It's also high reward, because with the right mix of quality products and service providers, they're going to have a better plan experience. Those participants and plan sponsors will have a better experience. So we would encourage advisors to help or to really nudge their plan sponsors to focus on having a good process in place for that service provider selection and monitoring activities. And then over on administration and reporting, the same is true here, except the high risk is from enforcement from DOL and or IRS primarily. And this is where a lot of little things fall through the cracks, but those little things can compound over time if they're not caught. And so again, an activity that we want to encourage plan sponsors to take more seriously, and advisors to bring to the plan sponsor some degree of process, something that they can follow systematically that will generate, consistent results and predictable output and so forth, which will then provide both you and your clients with additional time management and essentially scale at the end of the day. So if we look in those three buckets and we look at what the DOL would expect a plan sponsor to be able to, or even a plaintiff for that matter, to be able to bring to the table to show that they were in fact prudent, that they did have a good process in place, and that they made well-informed decisions as fiduciaries are required to do. Well, the only way we know what those decisions were and why they were made is by documentation. And so what we've done here at Pension Resource Institute, we've taken a lot of the Department of Labor investigation support that we provide to plan sponsors via our sister law firm, Retirement Law Group, and we see quite a few in every given year. We'll see these DOL document and information requests. It's kind of the shot across the bow letter, if you will, that the Department of Labor sends out to all plan sponsors, irrespective of whether that investigation was triggered for cause, as we would refer to it in the security side of the industry, or routine. In other words, was there a red flag that brought them in which case they'll supplement their questions with some very specific, drill down inquiries about that particular issue. But a lot of times it's more of the standard boilerplate in either case, and then they'll follow up with those more specific questions. So what we've done there is we've taken those document requests over the years and basically reverse engineered them to show plan sponsors, and in this case, show advisors, how to explain to plan sponsors what type of information they may want to have in those files. And one of the things that we found is by organizing the file in this manner, it further reinforces to the plan sponsors that their duties, fiduciary duties, extend well beyond investment selection and monitoring. It also provides for a well-organized file when delivering that information to the Department of Labor, or IRS for that matter. If they can see that the plan sponsor has a robust file that's well-organized, they timely produced it to the regulator, then they're much more likely to feel like there's nothing to see here and close that investigation and move on. If it comes in piecemeal and the plan sponsor doesn't know where to get this information, they're calling the advisor, asking you, what do you have that is responsive to this, or what's the TPA have, what's the provider keeping, and that will come in piecemeal. It will likely be more ad hoc in terms of the process, and the DOL will know, they will see that, and they know that if they just dig a little deeper, they're going to find something. And so those then tend to be protracted investigations, most oftentimes leading to some form of fine or penalty for the plan sponsor. What we've found over the years, just anecdotally, is probably about 8 out of 10 or 80% of the cases where the advisor is relatively new and the plan is investigated by the DOL, that advisor gets replaced. In other words, it's almost as if the plan sponsor said, you represented that you would keep this from happening to me or something like that. And so what we want to do is give you the best retention strategy you can, which is by helping proactively arm your plan sponsors with this type of knowledge so that they understand what they need to retain and have available to be produced. You can also see here the imbalance to a degree when it comes to administration and reporting. We actually had to make that column bigger to accommodate all of the things that would be in there to fit it on the page. Well, that in and of itself signals where some of that additional time should be spent with the plan sponsor. As an advisor, you can help liaison with the record keeper and or TPA, CPA in some cases with larger plans, other service providers to make sure that the plan sponsor is getting the information in its file that it needs for the administration. And on the service provider side, the good news there is this is not a quarterly activity. I know that a lot of you are evaluating funds on a quarterly basis. Nothing wrong with that. We would just encourage you to think about, again, on the time management side, are you spending an inordinate amount of time with the committee on investment-related issues, recognizing the risk may not be commensurate with that level of time commitment. And if we can deploy that additional time over into these other two categories, it will help you differentiate from those who are so focused on investments because that's what they know, that they don't ever get into these other two areas. And that's, as we saw in the Fidelity report, and I'm sure we'll see confirmed in the most recent findings, that's really what plan sponsors are looking for. It's holistic support from their advisor consultant across all three areas. The good news is, though, when it comes to service provider selection and monitoring, the work there is really on the front end, the due diligence in terms of evaluating the needs of that plan and its participants, mapping those needs to available services from, a number of potential service providers that serve that market, and benchmarking the fees in relation to the value of services being provided, et cetera. So there's some front-end work there to be sure. But then after you've done that, there's some degree of monitoring, making sure that the payments are actually coming out of the trust as they were designed to and per the agreement, monitoring that service provider's regulatory track record, if you will, or any kind of pending litigation that may be a red flag for the plan sponsor. Other than that, though, it's about every 3 years you'll want to go back and benchmark unless there's been a major shift with the plan. If there's a merger, then you'll want to go back and benchmark, make sure you're still getting good value for the compensation being paid to service providers. If there's a major turnover in the committee, you may want to go back and help the plan sponsor understand what decisions were made and why and how that stacks up against current market conditions and so forth with respect to fees. But again, it's not something you're doing every quarter as an advisor. So you can help more holistically here. If you're pretty surgical about where you spend your time, though, that's how you're going to get that scale, and that's one of the things we're going to look at before we sign off today. So this is taken from our GMAP series. At PRI, we make available a series called GMAP, stands for Governance Model Administrative Procedures. Again, this is an outgrowth of some of the legal work we were doing for plan sponsors or continue to do at Retirement Law Group. And for better or for worse, a lot of the plan sponsors that we run into don't have an advisor. And that's why they're reaching out to outside counsel. And so this is actually, this diagram that you're seeing here is the part of the map itself that is a flow chart that we, again, call GMAP. And what we're trying to show here is we've had plan sponsors ask us as outside counsel to help with a lot of the activities that advisors or consultants traditionally perform. And we don't do that all day, every day. We certainly don't want to compete with advisors, and we're not trained the same way the advisors are, so it would be risky for us to take it on. So this is actually a diagram that I ended up having to draw at one point, probably 8 or 9 years ago, for a plan sponsor, and I pointed to the icon, what is now the icon in the center, and I said, do you see that person there? That's not us. You need a consultant or advisor that can help you across all 3 of these areas. The information can flow through that advisor. Some of what flows through may be fiduciary in nature relative to the advisor, that being the investment advice or discretion they may exercise in that last bucket. But other than that, you're facilitating in a non-fiduciary capacity. You're just being more helpful and therefore driving more higher value would be assigned to your services, which can drive your fees. You could defend them higher fees for that. And then the information is being presented to the voting members of the committee. And I know a lot of you are going to say that, hey, we work with really small plans. Maybe we're too small to have a committee. That seems overly formal for the kind of plans that we work with. Maybe it's a startup plan. To which I would say, those are the plans that need a committee the most. And we're not talking about a committee just for the sake of having more people, in the meetings. We're talking about a committee for the sake of being able to package up information for that overburdened business owner who we can bet that the plan isn't the most important thing on their plate every day. And so you may need some additional expertise and other personnel that may or may not be executives in that organization. Maybe that's, the bookkeeper that's going to help track data in an Excel spreadsheet, manage to a calendar, and is familiar with submitting reports to governmental agencies. That person's going to be extremely helpful in the administration and reporting activities. Service provider selection and monitoring, maybe it's somebody that's in charge of procurement at that company could come onto the committee and really work with you and the other service providers to package up information in a way that then they can present it to the voting members of the committee. In my example, probably that sole business owner, present it to him or her, and then he or she can make an informed decision, document that decision, and move on. If you're trying to chase down that plan sponsor, that single business owner, to make those decisions day to day, a lot of things will fall through the cracks because they're just, as one advisor told me this morning, sometimes my clients go rogue on me and they don't want to be bothered and so forth. And so by having a broader representation of different skill sets that are critical to running a well-oiled plan, having them on the committee and being knowledgeable about the process is another way to really be able to position time management in addition to risk management as part of your value proposition to that business owner. We talk a lot about reasonableness of fees, and I'm very reluctant to talk to plan sponsors. I would encourage you to kind of think about how you're positioning fee-related information with plan sponsors. I tend not to talk in terms of cost, and you've heard me say it a couple of times already, talking in terms of value. And the reason I don't like to talk in terms of cost is you get some plan sponsors maybe reading the headlines and seeing that, plan expense, another plan expense, class action lawsuit, and they just get into this mentality of low cost at all costs. And some advisors will really piggyback on that momentum and come in and demand the record keeper reduce their fees and that the TPA or other service providers reduce their fees. Well, guess who's next? in that equation. And in some cases, those plan sponsors will drop the relationship with the advisor. That'll be the final piece of cutting fees. Well, when you cut costs, you're also cutting value. And so we want to be very careful. We talk to plan sponsors in terms of value, and the value of services is based primarily on the need. Do we even need that service? If we don't need it, then we don't care what it costs. It's too high. If we determine we do need that service, it's a necessary service for running the plan efficiently and productively, then we ask, okay, what is the nature of that service? What's the scope of the service? What is the frequency at which that service is delivered? And that's going to drive the value. We're also going to look at the background, experience, credentials, this is what the DOL tells us to look at, of that service provider. So if you've found yourself in a position where you are among the 5,000 advisors in the country that serve more than 10 plan sponsors, that's a value. You're going to help them be more efficient than the advisor who only has one plan sponsor client. So again, this is all value relative to the fees that you're charging, relative to the needs of the plan. This is something we put together, again, part of that GMAP series, but what we've done here on this slide, and we'd encourage you to print this out and obviously check with your supervising firm about getting approval to use something like this. But if you have an expansive menu of services, if these types of activities are within what you're able to provide and put in writing in a plan advisory agreement, for example, or 408B2 disclosure, if your supervising firm will allow you to put these types of services in writing, then this can be a very good prospecting tool. Because what we've done is we've just taken out all of the services that an advisor could provide and put this down on one piece of paper, and the plan sponsor can rank in terms of very important, or not important / unsure, these various activities. So if you know that the incumbent advisor is not providing holistic support, they're focused on what they know best, which is investments and investment performance, and that's all that's in their agreement or their 408B2 disclosure, that is where they have to articulate the services they're providing and the fees that they're receiving. If they're only checking off 1 or 2 boxes here, and you're able to check off 5 or 10 or more, then it's a pretty easy visual for the plan sponsor to see that at the same level of compensation, if they were to hire you, they would receive quite a bit more value just in terms of the nature and scope of your service. Forget all about the background experience, your credentials, et cetera. Just the first piece of that value equation is satisfied here in plain English. So as you can see, they're broken up and they're color-coded somewhat. That corresponds to some of the other materials we've seen, and orange is always representative of service provider selection monitoring, green being administration reporting, and gray is kind of the catch-all investments. The one thing I would recommend, though, before, in addition to making sure that your compliance department or supervisor has approved this type of content, the other thing I would make sure is that your agreement or your disclosures actually provide for the majority of these services, because if they don't, it's not going to be much of a prospecting tool, because the plan sponsor should be asking you, okay, now where in your agreement does it say you're doing these things that I've said are very important to me? So maybe you want to supplement your service agreement if you have the ability to do that, or petition to have it supplemented if you can demonstrate the requisite proficiency to your supervising firm before using this as a prospecting tool. In any event, something like this from the other service provider's perspective is something you may want to consider, or those of you that are affiliated with a PRI member firm, you do have that information available to you in the GMAP tab of Advisor Resource Center. This is what we're getting at here. This is kind of in a single 8.5 by 11 landscape page here, we've been able to really convey what it is meant by value, and what the plan sponsor or what the Department of Labor would require of plan sponsors when evaluating the reasonableness of fees. So they have a few seminal publications out there. One is called Tips for Selecting and Monitoring Service Providers, published by the DOL, updated every couple of years. If you haven't read that, I would encourage you to do so. And if you're able to provide majority of these services, I would encourage you then to also deliver that to your plan sponsors. It's going to help them appreciate the value of your services even more when the Department of Labor is telling them this is what they should be looking for. There's also another one that's even a deeper drill down, and this is something you want to coordinate again with your supervising firm, because it's going to require, if the plan sponsor then asks you all of these questions, you're going to have to get responses that the firm will stand behind. But it's called, and it was a joint publication with the Securities and Exchange Commission, and it's called Tips for Selecting and Monitoring Pension Consultants. So if you take a look at both of those, and you can just Google them, they'll pop up pretty easily. And that's valuable information. What we did is, again, kind of reverse engineered that guidance as well as other guidance that we've interpreted over the years and backed into this value matrix. And on the left-hand side of the y-axis, you can see these are all the fiduciary services. There's only so many ways you can differentiate fiduciary services. You either are a fiduciary or you're not. You're either providing fiduciary services at the plan level or participant level or both. And those services are either non-discretionary or discretionary. That's it. So where we find the biggest opportunity or best opportunity to differentiate is to be out here either in the second or third tier on the x-axis. These are all of the non-fiduciary items that will further solidify the value you're providing to the plan. Once you get entrenched in this sort of process, it's very hard to replace you, so it's a great retention tool. And if you're out here, particularly in that third category, you're part of, the upper decile of advisors in the country that can provide that service, that level of value. So too should your fees. You shouldn't have to compete then down in the very low end of the fees, because you can justify the higher fee based on the higher value. And you can see here in this non-specialist category, you can do a combination of these things. If you feel like you're only going to refer a third-party manager, which I know is an option you do have available on Ubiquity and other platforms, and you don't want to be that fiduciary on an ongoing basis, you can still couple that level of support with this third tier or second tier of non-fiduciary consulting support, and that's a viable business model. In fact, it's one we see quite frequently down, in the smaller plan market. And we've talked a little bit about this, but just kind of to recap so you have it all on one page. Value is the services needs to be in alignment with the needs of the client. So in other words, if the client is only looking for help with 3 or 4 things, but you're willing to give them 25 things, but you're going to give it to them at a really good deal, well, the other 19 are superfluous and probably shouldn't be factored in because the plan sponsor says we don't need help with that. So make sure you're understanding what the needs of that client is, both in the boardroom with the plan committee or the business owner, and in the break room with the plan participants. What is it that's going to be of value to that organization and its employees? And then we look at the nature, scope, frequency of the services. That should be articulated in your agreement. Be a little careful with frequency. We don't ever want to pin you down to be delivering something that could get missed. So we use phrases like periodically or upon request if we have to pin down frequency. Now, some of you might say, well, part of the value I'm delivering is I'm doing quarterly one-on-one participant education. Great. Make sure you articulate that. And if you are systematically doing it quarterly, then you probably do need to indicate that to in your agreement or disclosure, because that's one of the expectations the plan is going to have. And then background experience credentials, and that's something we're going to help you grow through some of these, I won't call them shortcuts, but let's just call them job aids, if you will. And so here, this is, again, a flow chart out of our GMAP series, but you're free to use this as you see fit. We're showing what the role of the advisor is on the left-hand side of the graphic, and then we're showing the role of the committee or that business owner on the right-hand side. And just for example, you're going to jointly evaluate the needs of that plan and the objectives of that plan. When it comes to introducing a platform or other service provider, that's your job because you can see across multiple plans. Your plan sponsors typically don't have that perspective. They may have known how their last plan operated at their prior employer, but they're not seeing the universe of product and service providers on a daily basis that you'll see. You may help them review the 408B2 disclosures or the agreements and compensation that is disclosed by the other service providers required under 408b2. You could jointly help them review the service provider credentials and introduce benchmarks. They're going to actually sign off on it, and they're going to exercise discretion over the selection, retention, or replacement of that service provider. So again, this is something you're not doing quarterly. This is something that is periodic, or as the needs of the plan change, or let's say you did convert to a new provider platform, you would probably want to go through this exercise again. But otherwise, it's about every 3 years. This is what we're looking at in terms of your role relative to administration and reporting. We're very careful here to show that you can be very helpful, but without overcommitting, right? So helping them, again, review the needs and objectives of the plan, clarifying the role of the various service providers. You probably brought that service provider to the table, so you're going to better understand what the limits of their services are. And then you can help them with some of the reconciliation, but it's, at the end of the day, primarily education and monitoring in this channel, at least for advisors. Investments, this is one where I mentioned you need not be an ERISA fiduciary in all cases, particularly now with the Department of Labor, the new fiduciary rule going away. You could recommend a third-party manager that's available through that platform. The plan sponsor engages that third-party manager. They have discretion. There's no room for you to give advice in the boardroom. You still may be exposed to being a fiduciary in the break room, so you want to be careful that if you're trying to avoid that status, that you're providing only investment education. And at least for the time being, the place to find that delineation between investment education and advice is if you just, again, Google Department of Labor Interpretive Bulletin 96-1. You'll see in there, it's about a page and a half. It's pretty easy to read. You'll see 4 different examples of investment education as opposed to investment advice that apply at the participant level. But again, you're helping evaluate needs. You're reviewing the IPS. Maybe you're bringing the IPS to the table. You're going to educate them on what investments are available through that platform. Again, this is if you're playing a non-discretionary, discretionary role. Otherwise, you may be introducing that 338 investment manager, which is just another name for ERISA discretionary investment manager. And then you're going to help them periodically review the investment policy statement. You may recommend some changes to that, et cetera. So again, just being able to show graphically the role you can play vis-a-vis, in this case, investments. So this is where we start getting into process, and I mentioned QDIA. I want to make sure we have plenty of time for some questions here, so I'm going to just up the pace a little bit. But this is one I didn't want to lose sight of, and it may be overkill for some of you that are not in that more than 10 plan category, but if you're trying to get there, I'll just arm you in advance. This can also be a very effective prospecting conversation starter. And the question here is that 4th one. It is, what process governs the selection and monitoring of the plan's qualified default investment alternative? As many of you know, sometimes we see 70 or 80% of the assets sitting in that QDIA. And that may be a great thing, right? If it's something that's automatically becoming more conservative over time, and the participant doesn't have to engage as much and understand when to start de-risking as they approach the retirement date, if they're going to roll the money into an IRA or what have you. So it's not necessarily bad that the plan participant gets to sit it and forget it, but the plan sponsor cannot set it and forget. And so what we see here, the reason for my alarm, is we see a lot of cases where there is no process. There's an investment policy statement, and it relates to how to select and monitor core funds, but there's nothing in there about QDIA. More specifically, the Department of Labor came out in 2013 with its tips for ERISA plan fiduciaries regarding target date funds. Given that those are by far the most popular QDIA, we want to pay a lot of attention to those tips. This is probably the most important decision a plan sponsor will ever make. And for those of you who have agreed to serve in a fiduciary capacity by advising on the QDIA, or certainly if you have discretion over QDIA selection, it's going to be one of the biggest areas that you can de-risk in terms of getting a good process in place that considers the information in that DOL's tips from 2013 regarding target date funds. One brief example. We see on average maybe 80 to 90% of participants rolling out of that plan, taking a distribution at or shortly after their target retirement date. In the DOL 2013 tips, one of the criteria it suggests plan sponsors review is withdrawal patterns. If you find that you're in that camp where 90% of the participants are rolling out at retirement, what happens if there's an aggressively managed through target date fund glide path that's, in that those short-term retirees are holding? It's going to mean they're going to have a lot of volatility, potentially a lot of volatility when they need that money the most. So that would either signal that we need to get a less aggressive glide path target date series in place, or we need to couple it with an aggressive information campaign telling plan participants why these investments are designed to be held through retirement and they're not designed to be liquidated at retirement, and they may be experiencing volatility, et cetera. So that's either, at a minimum, it's plan sponsor's problem. Worst case scenario, you've contractually agreed to have that be your problem, and there's no process in place. So make sure you have a robust process for selecting QDIA and very specifically target date funds. Service providers, when I talk about introducing a process, and I said it can be pretty simple, as open-ended questions, these 6 questions on the right-hand side of the page are designed to stimulate additional information gathering, some degree of debate and dialogue with that plan sponsor, and ultimately a well-informed decision. If you can show all of those steps in the fiduciary file, these 6 questions would have prevented 90% of the litigation we read about in the paper. It was the plan sponsor, believe it or not, these mega plans potentially have, just as many competing issues as the small plan sponsor does in terms of those fiduciaries that are charged with making decisions, and these types of things were missed. Or again, there would not have been any liability if they followed a prudent process, and I would submit that these 6 questions can get you there. Here's again some questions. This administration's a little bit more difficult to pin down a process because all plans are designed to a degree differently. They're operating differently. So what we want to know is there somebody, has the plan delegated this duty to oversee to somebody, some of these most critical factors, to somebody who's going to be there and have the skill set to oversee it and report back if something's amiss or that got missed. And we can catch that sooner rather than later. Likely it can be a voluntary correction. And you don't have the DOL settlement, you don't have the potential attrition that we see when plans are investigated and the advisor is kind of put on the spot. And then lastly, this all kind of, it results at the end of the day in more of a circle, more of a cycle of service. And so, if you can introduce these concepts in any given year, you can hit all 10 steps. We think that's for most agreements. It all depends on how your agreements are written, but for most agreements, you should have a pretty high degree of comfort that you've fulfilled your commitments that you've put in writing with your ERISA plan clients. And again, these are free for download, and you can use those. Anybody who's attended today can use these in their own practice. We would just ask that our copyright stay on the materials, but as opposed to reading these bullet points, I'll just let you follow up at your own pace on that. And as promised, we are now available to answer any questions. You can submit those through the chat panel, typically found in the right-hand side of your GoToMeeting pane.
Great, thank you, Jason. We do have a few questions, so I will get those started. The first one being, can you repeat the 2 articles you cited as suggested reading, please?
Sure. I suggested 2 articles relative to selecting and monitoring service providers. One is actually called that. It's a Department of Labor, quote unquote, tips for selecting and monitoring service providers for your plan, I think, for your retirement plan. That one's a higher level. It's much more readable for the average plan sponsor. The second one I mentioned is more technical, and that's the joint SEC and DOL publication called Tips for Selecting and Monitoring Pension Consultants. That's the one I said be careful, because if you give that to your plan sponsor, you can pretty much be assured they're going to ask you to answer those questions, and that's when you're going to want your supervising firm to sign off on, because what we don't want to do, the SEC in particular, and FINRA also to a degree, really in their examinations focused on misleading statements, sort of false advertisement, overstating AUM. AUM is a very technical definition, so you'll want to make sure you've got somebody signing off on what it is you're producing if you do get that sort of an RFP response from the client. The other things I mentioned, the other one that comes to mind here is the difference between what the Department of Labor considers investment advice versus investment education at the plan participant level. And that is Department of Labor Interpretive Bulletin 96-1.
Excellent. So another question submitted: is it possible to deliver this level of value and also avoid becoming an ERISA fiduciary?
Absolutely, and I alluded to that a couple of times where I'm going to try to answer this without getting too into the weeds, but if you'll recall, when the Department of Labor expanded the definition of investment advice, and that definition became applicable last June, one of the things that was not previously covered that was now considered non-fiduciary or a non-discretionary investment advice, therefore making you a fiduciary, was recommending a third-party manager or a third-party advisor. With the vacatur in effect now, presumably in effect, we have not seen the final order in the court, but we may never see that. That means that piece went away. So what we revert back to is the test for investment advice that was articulated by DOL in 1975. And in that guidance, it said the advice to be fiduciary in nature must relate to the advisability of investing in securities or other in property. And typically your third-party money managers or TAMPs or others that are actually RIAs at the end of the day, they're not securities and nor are they property. So it's, again, check with your supervising firm in terms of how to classify this. I know that on the PRI member side, we have about 60 firms there we work with, and I think every firm is interpreting, taking a little bit of a different tack on that particular issue. But at the end of the day, the short answer is you can now make a one-time recommendation concerning to the plan sponsor to hire that third-party manager. You'll want to make sure that you've done some due diligence so you can support that recommendation. But potentially, presumably most of the providers are working with reputable third-party managers that are connected to their platform. And if you recommend the plan sponsor use that option, now you've taken yourself out of any opportunity to be considered a fiduciary in the boardroom. You have not walled yourself off or insulated, vis-a-vis any participant conversations you're having. But again, that's where that Department of Labor Interpretive Bulletin 1996-1 will come in handy there, because it would very, very, I think, surprisingly to a lot of you, you'll be surprised at the latitude you're afforded, particularly when it comes to discussing model asset allocation portfolios with participants, that you can even do that and still have it be considered investment education and not fiduciary advice. So long way of saying, yes, you can absolutely do that. And even some very sophisticated advisors that serve as a fiduciary in the boardroom all of the time in larger plans, I've seen them over the last 5 or 6 years really start using this option of a third-party manager in the smaller plans, just because they need to focus the critical small amount of time they have with plan sponsors when they have their attention. They need to focus them on these other two buckets, namely service providers and administration or reporting, and not get bogged down in the investments and not take on that risk and with a small plan that may not follow your lead on what you're advising. So we've seen some advisors that are prohibited by supervising firms from serving a fiduciary capacity embrace that model where they're higher touch in the boardroom, but they're not a fiduciary because of the third-party manager. We've also seen other advisors just looking for more economies of scale using that option as well.
Great. And we have time for one more question. So the final question today for you, and I think you did a good job of highlighting this in your sample needs assessment worksheet, which is great for prospecting. But what is a good way for me as an advisor to highlight to my clients and prospects who are unfamiliar with the term fiduciary? So what's a great way for me to highlight that I'm a fiduciary?
Well, the way that you're legally required to highlight it is in your, I've said the term 408B2 disclosures. Typically, we see a 408B2 disclosure being delivered by a broker-dealer where the comp is paid indirectly. You may be getting compensated via trails from the insurance platform, or 12B1 fees from the mutual fund platform, or what have you. And so you don't have an advisory agreement. You're not serving in a registered investment advisor or investment advisory representative capacity. And so that's when I tend to refer to 408B2 requirements. But it requires that those services be articulated in sufficient detail so the plan sponsor can determine whether or not it's reasonable and it's necessary. And one of the requirements there is that each of your services be disclosed, any of those that are going to be performed as an ERISA fiduciary, that you acknowledge your fiduciary status relative to that service. The equivalent in the RIA market is your advisory agreement. For example, in the advisory agreements that we make available at PRI, we have the 408B2 required disclosures in the first 4 pages. Services, compensation, and status as an ERISA fiduciary is covered right out of the gates. And so you could use that as a proposal tool, as a change form. You could use a point of sale with the remaining terms and conditions of the agreement. But some of you may have agreements that nevertheless satisfy 408B2, but the services may be in an exhibit, the fiduciary acknowledgments embedded somewhere in the terms and conditions, compensation may be another exhibit at the end of the document. But that is something critical to make sure where you're serving in a fiduciary capacity. Not only do you want to highlight that because of the additional value that will convey to the plan sponsor, but you're legally required to highlight that.
Jason, thank you so much for this informative discussion talking about sponsor challenges and opportunities for the advisors. We appreciate everyone participating today. We will be emailing this slide deck to everyone that has registered, and the audio that has been recorded will be available in the next few days. If you have any questions, feel free to reach out to Ubiquity at partnersupport@myubiquity.com. Thanks everyone for your time.
Thank you.